One small paperwork mistake could cost your family thousands, and most people don't even realize they've made it. Do you have a will that's outdated, missing beneficiaries, or worse, no plan at all? Estate planning isn't just for the wealthy, it's about protecting the people you care about and making sure your wishes actually happen. In the next few minutes, I'll walk you through the most common estate planning mistakes and how to avoid them, so your assets go where you want, without unnecessary stress, delays, or expensive surprises. Relying solely on a will without setting up beneficiary designations and trusts, where appropriate, can leave your estate exposed to delays, costs, and unintended outcomes. A will only governs assets that go through probate, which is a court-supervised process that can take months or even over a year, and often costs 2 to 5% of the estate's value in legal fees, court costs, and executor expenses. For example, if you have a $500,000 estate, probate costs alone could reach $10,000 to $25,000. Assets like retirement accounts, life insurance policies, and payable-on-death bank accounts pass directly to named beneficiaries and avoid probate entirely. But if you forget to update these designations, your money could go to an ex-spouse or bypass intended heirs. Trusts, particularly revocable living trusts, allow you to control how and when assets are distributed, avoid probate, and maintain privacy since trusts are not public record. They can also help manage assets for minor children or beneficiaries who may not be financially responsible. From a tax standpoint, while most estates won't trigger federal estate tax due to high exemption limits, state-level estate or inheritance taxes may still apply, and trusts can help with planning around those thresholds. The actionable step is to inventory all your assets, verify every beneficiary designation, and determine which assets should be retitled into a trust. Coordinate your will with those designations so everything works together rather than conflicts. Failing to update your estate plan after major life changes can result in outdated instructions that no longer reflect your wishes and may create costly legal disputes. Life events like marriage, divorce, the birth of children, or significant changes in your financial situation should trigger a review of your estate plan. For instance, if you divorce but forget to update your will or retirement account beneficiaries, your ex-spouse could still legally inherit those assets depending on state law and plan rules. Similarly, if you have a child and do not update guardianship provisions, the court will decide who raises your child if something happens to you. Financially, this can lead to misallocated assets and even tax inefficiencies if your plan does not account for new income levels or asset growth. For example, a life insurance policy purchased when you earned $50,000 a year may now be insufficient if your income has doubled and your financial responsibilities have increased. Regular updates also ensure you take advantage of current tax laws, such as annual gift tax exclusions or changes to estate tax exemptions. The practical approach is to review your estate plan every 3 to 5 years or immediately after any major life event and coordinate updates with both an estate planning attorney and a financial advisor to keep everything aligned. Not planning for incapacity with powers of attorney and healthcare directives can create financial and medical chaos if you become unable to make decisions for yourself. Estate planning is not just about what happens after death. It also covers what happens if you are alive but incapacitated due to illness or injury. Without a durable power of attorney, your family may need to go through a court process called guardianship or conservatorship to gain control over your finances, which can cost thousands of dollars and take weeks or months. During that time, bills may go unpaid, investments may be neglected, and critical financial decisions may be delayed. A healthcare directive or living will ensure your medical preferences are honored and designates someone to make healthcare decisions on your behalf. For example, if you have strong preferences about life-sustaining treatments, those need to be documented clearly to avoid family conflict. From a financial standpoint, delays in managing accounts could lead to missed mortgage payments, late fees, or forced liquidation of assets at unfavorable times. The solution is to establish a durable power of attorney for finances and a healthcare proxy or living will, and to choose trusted individuals who understand your wishes. Keep these documents accessible and ensure your chosen agents know where to find them. Underestimating estate taxes and not planning to minimize them can result in a significant portion of your wealth being lost to taxes that could have been reduced or avoided. While the federal estate tax exemption is currently high, over $13 million per individual as of recent law, it is scheduled to decrease in the future, unless legislation changes. And several states impose their own estate or inheritance taxes with much lower thresholds, sometimes as low as $1 million. If your estate grows over time due to investments, real estate appreciation, or business ownership, you could unexpectedly cross those limits. For example, a family with a $2 million home and $1 million in investments in a state with a $1 million exemption could face state estate taxes without proper planning. Strategies like annual gifting, which allows you to give up to a set amount per person each year without triggering gift taxes, can gradually reduce your taxable estate. Irrevocable trusts can remove assets from your estate while still allowing you to define how they are used. Life insurance held in a properly structured trust can provide liquidity to cover estate taxes without increasing your taxable estate. The key action step is to project your estate's future value, understand both federal and state tax thresholds, and work with a tax professional to implement strategies that preserve more wealth for your heirs. Keeping your estate plan disorganized or failing to communicate it to your family can lead to confusion, delays, and costly mistakes when your plan needs to be executed. Even a well-designed estate plan can fall apart if your executor or beneficiaries cannot locate key documents, account information, or instructions. For example, if your family cannot find your will, trust documents, or a list of accounts, they may have to spend weeks tracking down assets or even initiate legal proceedings to reconstruct your intentions. This can increase administrative costs and delay distributions. Similarly, if your executor does not understand your wishes or the structure of your plan, they may make errors that lead to tax inefficiencies or disputes among beneficiaries. Consider a situation where multiple heirs are unaware of unequal distributions. This can create tension and potential legal challenges. From a financial standpoint, delays can mean ongoing expenses like property taxes, insurance, and maintenance continue to drain the estate. The practical solution is to create a centralized, secure record of your estate plan, including documents, account lists, passwords stored safely, and contact information for your attorney and advisor. Communicate the overall structure of your plan to your executor and key family members so they know what to expect, even if you do not disclose every detail, ensuring a smoother and less costly process.